Hello there, this is Professor Nathenson. You're watching this video on my YouTube site. This is the first in a series of short videos on selected topics in discovery and disclosure. These videos are intended to be a supplement to your reading. So let me caution you from the beginning. What you need to do for each part of the assignment is, first you gotta do the reading, okay? So read the rule, read the sections of the book, and then prepare the answers to the study questions and look at any assigned handouts. Then and only then should you look at the videos that I posted. So if you're watching the video before you do the readings, then you are only guaranteeing that you're going to get a lower grade because you're not doing the legwork. These videos will help you the best if you do the legwork first and then watch the videos. So you've been cautioned. Please act accordingly so that you can maximize your performance on the exam and that you can learn the materials the best, because these materials are central to lawyering. In fact, let me start off with rock, paper, and scissors. Here's an example of a case decided nearby in the center of the state. U.S. District Court for the Middle District of Florida, 6 years ago. Nothing is disputed as much as discovery. Now, discovery and disclosure is, of course, how each side gets information from the other side. The difference between disclosure and discovery is disclosure is automatic. You have to provide it to the other side, even if you're not asked. Discovery is something you have to ask for. Well, in both cases, these things are oftentimes disputed by the parties. There's oftentimes about how much has to be produced, whether something must be produced, or if it's not, why wasn't it produced, and so on and so forth. Well, courts hate dealing with discovery disputes, and here's one example. The court was so disgusted at the counsel's inability to resolve a discovery dispute that in the end, the court said to resolve the discovery dispute, the lawyers had to get together, have a paralegal, to play a game between counsel of rock, paper, and scissors, and the winner of the engagement was entitled to select the location for a deposition. So that seems kind of silly, but here the court, of course, was trying to express its disdain for the parties not being able to get along. What's true is there's nothing that's more disputed than discovery, and whereas in common law, the fight was usually in the pleadings. In modern litigation, most of the fighting is in the scope of discovery. You, of course, know rock, paper, scissors, or if you're a little more hip on pop culture, you might know rock, paper, scissors, lizard, Spock. That's, of course, a reference to Big Bang Theory. Well, let me talk a little bit more about what you're going to be doing. Obviously, you want to read the rules. Here's just one example, Rule 26B, very important rule. We'll mark that up later. There's a whole bunch of discovery rules. What you want to do is read those rules, then read the stuff in the case book, and then do the study questions. And what I'm going to do with you guys in these videos is I'm going to go through selected study questions here and comment on various aspects of discovery and disclosure. Now, before I move into this a little bit more deeply, I want to note something very important. Discovery and disclosure don't start until after the 26F conference. You'll recall the 26F conference is between the parties. Excuse me, no, I'm getting ahead of myself. Let me rephrase. Under Rule 16B, the court issues a scheduling order. Later on, we're going to find that discovery doesn't start until sometime after that. You may think, well, if discovery doesn't start until after there's been a 16B conference, okay, somewhat later in the litigation, then how do the parties get the information they need to file the complaint under Rule 8A and to answer under 8B? And the answer there is you engage in investigation. Indeed, Rule 11, 11B in particular, flat out says that you have to make an inquiry reasonable under the circumstances, and then by signing your complaint or answer or whatever, and then filing with the court, you're making certifications of no improper purpose. There's non-frivolous law. Factual contentions are also non-frivolous, and the same regarding denials of factual contentions. Well, if P is going to sue D, P can't just call up D on the phone and say, "Hi, I'm going to sue you, buddy. Can you give me all the information I need in order to state a claim under FRCP 8A2? D is going to say, "Take a hike." In fact, we've read the case involving the people that sued, I believe it was Sony, for copyright infringement when they adapted a manual. And the lawyer, of course, got in trouble under Rule 11B and 11C because the lawyer hadn't engaged in factual investigation, right? The court said, well, at least he had to try, even if Sony wasn't going to cooperate. Well, what I'm going to say to you here now is to remind you that even though we're going to be talking about disclosure and discovery, nonetheless, a big tool in the lawyer's toolkit is engaging in investigation, informal investigation. What I mean by informal is investigation the counselor or the paralegals or investigators or even the client engage in to start building a case. And that can be done before the filing of the complaint. In fact, it must be done before filing the complaint because of that inquiry that's required by Rule 11B. And indeed, it can continue throughout a case. So informal investigation is always an option. The difference between that and disclosure and discovery is that disclosure and discovery are things that are provided for in the rules. Things that disclosure a party must do, or discovery a party must provide upon request, if that request is otherwise proper under the rules. Now, I'm going to spend a few minutes here now talking about some of the rules and giving a very brief overview of them, and then we're going to jump much more deeply into Rule 26 and the scope of discovery. Now, Rule 26 is the heart of discovery. It's a really, really big rule. It's a long rule, and it goes on for something like 11, 12 pages in your statute book. Don't be intimidated by it. What you need to do is use the study questions and break things into bite-sized chunks. So you'll see here, you see here, I'm guiding you towards different parts of the rule, okay? Well, use those as your treasure map and to make sure that you're understanding how to answer each one of those questions. In fact, you'll see that Rule 26 has a lot of important things about the scope of discovery, timing of discovery, certification for discovery, things that fall under the disclosure requirement, when there's a duty to supplement disclosure or discovery responses, and so on. In fact, each part of Rule 26 itself is, in essence, a different rule. So treat 26A and 26B almost like they're separate rules, okay? And cut it into bite-sized chunks and you'll do better. I'm not going to really talk about Rule 27. Let's instead talk about Rules 27 through 31 together. Those are rules dealing with depositions, okay? We'll talk about depos more. A deposition is oral testimony done under oath. So the person who's speaking under oath is called the deponent, okay? And they will answer questions. Those answers might be by written questions that are pre-submitted by the lawyers, or more commonly by oral examination where the lawyers and the witness are all there in a room, typically in the offices of one of the lawyers, and they're asked a bunch of questions. There's examination, cross-examination, and so on and so forth. That's a deposition, and afterwards a transcript is produced. It might be in a printed form, such as taken by a court reporter. It might be video. It might be videotaped, and so on and so forth. All right. Now, Rule 27, we're not going to really talk about. That's going to be in cases when somebody's not going to be available later on, and upon court order, the court can order a deposition of someone to record their testimony, to take their deposition testimony in cases when it might not be possible to get their testimony later on. Say, for instance, somebody's going to die. Okay. Rule 28, persons before whom the depositions may be taken. That's talking about the court reporter. Okay, the person that sits there and actually types up the stenography and administers the oath and things like that. Okay, so that's depositions. Again, we'll get back to that later in a separate video. Rule 33, oh, I should have said 27 through 32, my bad. Again, we're not going to really talk about Rule 32 all that much. Rule 32 combines with the federal rules of evidence and determines when depositions can be used in court proceedings, and we're really not going to get into that. We're going to keep things pretty basic. All right. Rule 33 is interrogatories to parties. And interrogatories to parties are, again, questions to the parties that have to be answered under oath, and you think maybe that's the same thing as a deposition. But no, a deposition, the answers to the questions are done live via spoken answers. Okay? That's how a deposition works. Interrogatories are written questions. Okay? So that means it's kind of like a Rule 31 deposition by written questions. But under Rule 31, deposition, still the answers are live and by spoken answers from the deponents. With interrogatories, Rule 23, everything is written. Written questions and written answers. Generally speaking, interrogatories have limited applicability because the questions are typically written by the lawyers, and they're written to be really broad. And the answers are, again, drafted by lawyers, and the answers are typically very narrow and oftentimes even non-responsive. So much for that. Rule 34 is about producing documents, electronically stored information, things, or going to a land or a place to inspect. Okay, so that here we're talking about production of documents, going to places, electronically stored information, kind of like what we see going on with the just recently with the Hillary Clinton emails and the Anthony Weiner computer and all of that. You know, the FBI would be looking not just at the emails, but also probably the metadata and things like that. So we'll talk about that more later. Physical and mental examinations under Rule 35. That's when you do an examination, for example, mental health or physical health or things like that. Important things to note about Rule 35 is that you can only get that of a party or somebody under their custody or control, whereas depositions you can get against any person, whether they're a party or a witness. Let's see. And it has to be by court order. You know, unless the parties consent to the examination, a Rule 35 examination requires a court order. All right. Rule 36 are requests for admission. That's akin to a Rule 8A factual allegation and an 8B denial or admission. So if you think about how under 8A, claimants that are trying to state a claim can make an assertion of fact, an allegation of fact. Well, similarly, under Rule 36A, the discovering party can make a statement, you know, a request to admit, really. Just like admit that blah, 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 blah. Admit that you were driving the car. Admit that you were drunk. Things like that. So request for admission. And then under Rule 36, there's a request for admission. And then the responding party has to admit or deny that request for admission. So it's a useful way of getting information. It's typically done later in the case. Now, I'm not going to be doing a video on this because we're going to have a live class on this, but I'll just briefly note that sanctions for discovery are covered not under Rule 11. You will recall that 11D said that sanctions under Rule 11D don't apply to discovery. And that's because there's a whole rule dealing with for sanctions for discovery violations. And we'll talk about that more in the live class. All right, so that's it for this video. These videos are intended to be fairly short so they can be consumed in bite-sized chunks. So we'll see you in the next video.